Okay, so we are back. I see, Lisa, you've got your hand up. Go ahead.
Hi, Professor. I'm just looking at, sorry about the birds. I'm just looking at one of the previous sections you mentioned, 256 1.2F.
Yep.
I remember you were discussing F1, A, and B, which I noticed were repealed. I guess just like for future reference, do you want us to look into those as well, or is it more of just for our information kind of thing?
Yeah, those were repealed, so they were replaced obviously with what are now 2, 3, and 4 in their current form. So you don't have to make reference to those. You can skip.
Okay, thank you.
Welcome. I am actually would not be shocked if the bird sounds attract my cats. So I will soon potentially be the one apologizing for things interrupting us, quite possibly. So if we move on to slide 14. So here we have another association problem. I think I'm just looking at these things, and I think if you enjoyed logic games on the LSAT, you're probably having a great time this week. If you didn't, this is probably not entirely the most fun part of this, but you're here in corporate tax, you probably did pretty okay on the logic game section of the LSAT. So maybe this is your heaven. Problem 6.2. We have in this case A and brother B. A owns 100% of BCO. B owns 100% of BCO. BCO and CCO, sorry, ACO and BCO both own 50% of CCO. So our question here is, are any or all of these corporations associated with one another? And again, spoiler alert, like for all of these problems, the answer is yes, right? So here, yes, ACO, BCO, CCO are all associated with one another. Again, our starting point in our analysis is that A and B are related to one another pursuant to paragraph 251.2a and subsection 251.5. So ACO and BCO are obviously related to one another under subparagraph 251.2b3, and they're obviously both related to CCO as well under subparagraph 251.2b2, since they are a related group that controls CCO. So everybody's related, which is an important starting point in our analysis. So then, before we get to the attribution rules, right, again, we would, in this case, would conclude that nobody is associated but for our upstream ownership rules, right? Because, both corporations are controlled by a single person. The single person is related to the person who controls the other corporation. Cool. But there's no cross share ownership. So you'd say, well, at this point in our analysis, paragraph 256.1c can't apply. And moreover, you would say, well, CCO isn't controlled by anyone, right? And it's extent it's controlled by anyone. It's not controlled by the same group of persons who controls one of the other corporations. And therefore, it shouldn't be associated with anybody either under any of paragraphs 256.1a through e. And so before I start applying look-through rules and deeming rules, well, no one's associated. But then we do have to apply those rules. And so the look-throughs especially are going to start changing things up. So first, we apply paragraph 256.1.2d. And paragraph 256.1.2d applies to deem A and B to both own 50% of the shares of CCO. So now CCO is controlled by the related group AB. A controls ACO. A owns at least 25% of the shares of CCO. And so now the paragraphs of the conditions of paragraph 256(1)(d) are satisfied in relation to ACO and CECO once we apply the look-through rules, and the same applies to BECO and CECO, right? So we're in actually the same situation that we were in one of our earlier problems with our AB group, or B was the spouse of A's brother who was a U.S. resident. Same result as in that problem, right? Where we've now got everybody's associated after we apply the look-through rules, because of ABCO being associated with ACO and BECO under paragraph 256(1)(d). And then, because they're both associated with ABCO, ACO and BECO are deemed to be associated with one another under subsection 256(2). So notwithstanding that there's no cross-share ownership between ACO and BECO, the fact that they're both associated with ABCO causes them to be deemed to be associated with one another, and that's the ball game. Everyone's associated. Right, we doing okay there? Assuming that we are, let's flip to slide 15. And slide 15, in this situation, we have A owns 99% of ACO, B owns 99% of BECO, and there is, can I explain 256 sub 2 generally again? Yes, I can do that. Okay, so subsection 256(2), it's, like I said, it's the same functionally as subsection 251(3). So if two corporations are not associated with one another, but would both be associated with a third corporation, or would both be deemed to be associated with a third corporation, then they're deemed to be associated with each other. So in our last problem, once we applied the look-through rules, ACO and BECO were never associated with one another, but they were both associated with CECO. And that was in and of itself enough to cause ACO and BECO to be associated with each other, even though they otherwise would not be. Yes, Leah.
I just missed through what provision ACO and CECO are associated.
Yeah, so ACO and CECO end up being associated under paragraph 256(1)(d), which is the one that applies where ACO is controlled by an individual and ABCO is controlled by a related group. So that's the one that gets them.
Okay, thank you.
Welcome. So I think if that's everything on slide 14, again, we can go to slide 15. And so, like I said, A owns 99% of ACO, B owns 99% of BECO. A and B are related. There's 1% cross ownership in both corporations. We are assuming here that there's only a single class of shares, so it's only a 1% cross ownership. ACO and BECO are obviously related to one another. A and B are obviously related to one another. We're all good there. So the question is, are the corporations associated? And, again, I kind of ruined the surprise here on the last slide. Yeah, they're associated, right? This was a spectacularly dumb move by whoever did this to create this 1% cross-share ownership. I'm not sure why they would have done this in real life, but obviously somebody did. So the important parts here are, number one, that paragraph 256(1.2)(a) deems A and B to be a group in respect of ACO and in respect of BECO, notwithstanding that, obviously they would in fact be a group at common law. I don't think there's ever been a case where related persons are not a group at common law. So they would have been a group anyway, but they're deemed to be a group. They're super deemed to be a group by paragraph 256(1.2)(a). So that's fine. But then paragraph 256.1.2b deems that it does not matter that A co could control A co by himself and B co could control B co by himself. The groups, group AB is deemed to be a group, and group AB is deemed to simultaneously control A co and simultaneously control B co along with A and B. So as a result, that group AB controls both A co and B co, and now both corporations are associated with one another under paragraph 256.1b by virtue of being controlled by the same group of persons. So, for this purpose, it doesn't in fact matter that the cross shareholding is only 25, is only 1%, right? Which is obviously less than 25%. It would matter if we were into paragraph 256.1c, but we're not, right? Like if the cross share ownership only went one way, so let's say A owned 1% of B co, but B did not own any interest in A co whatsoever. So A co was only ever controlled by A, even after we've applied paragraph 256.1.2b. Like in that case, you'd be into paragraph 256.1c, and the corporations wouldn't be associated. But because this 1% share ownership goes both ways, you're into paragraph 256.1b, and everybody's associated. So, like I said, this is a dumb structure that you probably would not see in the real world, at least not in this exact way, but it illustrates the danger of paragraph 256.1b and 256.1.2b nicely. So everybody okay with that? All right, so if we flip to slide 16, and we go to slide 16, we have a what's actually a very similar problem, right? And in this example, we have X owns 51% of OPCO 1, 49% of OPCO 2. Y owns 49% of OPCO 1, 51% of OPCO 2. So basically mirror shareholdings. We don't know if X and Y are related in this case. We can assume they aren't, but we don't care. It is ultimately where we get to on this one. And the analysis, like I said, is substantially the same as in the last problem. So our starting point is that paragraph 256.1.2a deems X and Y to be a group in respect of both OPCO 1 and OPCO 2. Like this is where paragraph 256.1.2a really could matter if they're unrelated, because unrelated persons being a group is pretty dicey. But here they're deemed to be a group, right? So we don't have to worry about the diciness of that proposition at common law. We just know that they are in fact a group. And then paragraph 256.1.2b deems group XY to control both OPCO 1 and OPCO 2, notwithstanding that X has enough votes to control OPCO 1 and Y has enough votes to control OPCO 2. Group XY is deemed to simultaneously control OPCO 1 and OPCO 2. And so as a result, group XY, because it simultaneously controls both corporations, then the corporations are controlled by the same person or group of persons, and they're associated under paragraph 256.1b. So again, not sure that you see that exact problem in real life either, where the corporations just have these weird mirrored shareholdings, for some reason, where one person controls one but not the other. especially with unrelated persons. I don't know that anybody would really do that, but seems possible at least. So again, something to be aware of. Are we all okay there? Okay, so if we flip to slide 17, then we now have a different problem, but it's one we've talked about before. So I think just as you're probably looking at the slide, you probably know what the answer to this is going to be, even if I hadn't already told you that everybody's associated in all of these problems. Here, if you were paying attention for the last couple hours, you sort of know what the answer is, right? So the starting point in solving this problem is to deal with the trust, right? And so here we have subparagraphs 256 1.2 F2 and 3. We don't know if the trust is testamentary or de vivo, so it doesn't matter because 2 and 3 are there. And either one of those is going to deem Junior to own 5% of the shares of XCO. And then you're going to layer subsection 256 1.3 on top of that. Again, assuming that Junior is a minor. It would be a weird name if Junior wasn't, but assuming Junior is a minor, layer that on. And now it deems Mr. A to own 5% of the shares of XCO, and it deems Mrs. A to own 5% of the shares of XCO. So you'd say, well, all right, so this is potentially bad now because Mr. A now is deemed to own 100% of the shares of XCO and 1% of the shares of YCO. And then, notwithstanding this is mathematically impossible, Mrs. A is deemed to own. Mr. A is Mrs. A is deemed to own 5% of the shares of XCO and 99% of the shares of YCO. And so now that we've done this, the problem ties back into the last two problems, right? Where it gets to starting to get to the same place, where again, Mr. A and Mrs. A are a group that controls YCO under paragraphs 256 1.2 A and B, notwithstanding that Miss A has enough votes to control YCO all by herself. And then because we've applied our fiction, our deeming rule, that Miss A owns 5% of the shares of XCO because of the trust for Junior, due to the applications of subparagraph 256 1.2 F 2 and 3 and subsection 256 1.3, then Mr. A, Miss A are a group that controls XCO as well. Again, notwithstanding that Mr. A has more than enough votes to exercise control of XCO all by himself. So now our AA group controls XCO, our AA group controls YCO, and that's the same group that controls both corporations, and therefore they're both associated under paragraph 256 1B. Notwithstanding it, that there wouldn't otherwise be enough cross-share ownership in this case to cause any other association provision to apply. So not an overall great idea, right? The like I said earlier when we talked about paragraph 256 1.2 F and subsection 256 1.3, in this case where you have husband and wife who are both carrying on businesses separately through corporations, that trust for the minor was not a good idea, right? It caused an association problem for you. There would not have been one otherwise. It has it would cause, the sharing of the small business deduction between X and Y, and it would cause you to have two very irate clients at the end of the day. So not a good result in real life. Everybody okay with that? Okay, so seeing no one, we can flip over to slide 18. And in slide 18, we have our sort of weird sandwich structure here, where XCO owns 40% of ZCO directly, and X owns 40% of ACO, which owns 30% of ZCO, and unrelated shareholders own 60% of ACO. So in this case, we don't know about ACO. We're never going to get to the answer on whether ACO is associated with anybody, so we can assume it isn't. But what we're going to see is that XCO and ZCO are associated in this example. So before we apply the attribution rules here in this problem, we would say XCO and ZCO probably are not associated, right? They might always be associated because of, like there might be some de facto control issue or something that we aren't taking into account, or some separate existence problem. But we would start from the position that they are not associated, right? Because XCO does not own enough votes to control ZCO, and therefore they wouldn't be associated under paragraph 256(1)(a). And we don't know much about the shareholders of XCO. We don't know much about these unrelated shareholders in ACO. So we just don't know if there's some other kind of control that we're missing, right? So we just assume they're not associated. ACO and ZCO should not be associated because ACO is controlled by this unrelated group, and XCO is controlled by some unknown group. Nobody controls anyone directly. So again, probably your starting point should be that they're not associated. However, we do have to turn through the look-through rules. And so our relevant look-through rule here is paragraph 256(1)(d), 1.2d rather. And that requires us to look through ACO. Right, and so we'd say, okay, well, ACO has 100 outstanding shares. XCO owns 40 of those outstanding shares. So there only appears to be one class. So it should own 40% of the value of the ACO shares, and therefore it should own 40% of the 30% of the ACO share of the ZCO shares owned by ACO on our look-through basis. And 40% of 30% by my math is 12%. And so as a result of owning 12% of the shares of ZCO on a look-through basis, XCO owns owns or is deemed to own a total of 52% of the shares of ZCO. So that combined share ownership is obviously more than enough to have voting control. And therefore, XCO does control ZCO, and therefore they are associated under paragraph 256(1)(a). So I think that one was just slightly easier for everyone to wrap their heads around. But any questions there? Okay, so again, seeing none, we can flip to slide 19. And so in slide 19, we have 3 corporations. We know nothing about who their ultimate shareholders are, but we have XCO and YCO. XCO owns 40% of the votes and 60% of the value of the shares of ZCO. And YCO owns 60% of the votes and 40% of the value of the shares of Zedco. So, like I said, again, the answer is everybody is associated, and the question is really just how we're getting to the bad result. And in order to really appreciate how we get to the bad result, the important thing to, like, I'm going to say the important thing, but in understanding how we get to the bad result, it's useful to keep in mind a Federal Court of Appeal decision called Leartech, which also, there's also a tax court decision where the tax court comes to the same conclusion as the Federal Court of Appeal, which is always helpful. And what that case stands for, the proposition that you can have deemed control as a result of the association's supporting rules, notwithstanding that there's actual control before you start getting into legal fiction land that just based on ordinary principles, somebody controls. And the result is that you just have simultaneous control, not that somebody doesn't control or they cease to control or they don't control for this purpose. You just have simultaneous control is result. And then, once you've got simultaneous control, then you apply the rules and the chips fall where they may. So, and again, this is consistent with paragraph 256.1.2b, which very clearly allows for simultaneous control of corporations. So in Leartech, just to expand on the facts there a little bit, like the basic fact pattern was that there was you had a situation where you had shares of a corporation that would have been a CCPC had the corporation been controlled solely by the people who controlled it, de jure, but you had people who were otherwise deemed to control under the association rules, and if they controlled the corporation, was not a CCPC. And basically what the courts did was said, well, this is a situation where you have two different kinds of control. One is de jure control, one is deemed control. And it doesn't matter that somebody has de jure control. Deemed control exists simultaneously, and therefore both the real controller and the deemed controller control simultaneously. And as a result, the corporation is associated with both the deemed controller and the deemed controller and the de jure controller, which in that case resulted in the loss of various tax benefits. So before we start applying any crazy deeming provisions, we know in this fact pattern that YCO and ZEDCO must be associated, right? Because YCO owns 60% of the voting shares of ZEDCO, therefore it has de jure control, and therefore YCO and ZEDCO must be associated under paragraph 256(1)(a), right? So that's pretty straightforward. But then we have to go to subparagraph 256(1.2)(c)(1), and under that deeming rule, XCO is deemed to control ZEDCO because XCO owns shares of ZEDCO with more than 50% of the fair market value of all of the shares of ZEDCO. And again, subparagraph 256(1.2)(b)(1) permits control simultaneously by both XCO and YCO, notwithstanding that YCO in real life controls ZEDCO. So as a result, XCO and ZEDCO are also associated under paragraph 256(1)(a) because XCO is deemed to control ZEDCO. And so if that isn't quite bad enough, then because XCO and YCO are both associated with ZEDCO, then subsection 256(2) applies, and it's going to deem XCO and YCO to be associated with one another because of the common association with ZEDCO. So, everyone's associated at the end of the day, and your only real recourse is that for subsection 125.1 purposes, in order to claim the small business deduction, you could maybe have ZEDCO elect to not be, elect to just have its business limit set to nil, which would disassociate XCO and YCO. That's your only real recourse here. So that one actually, that one does happen in real life, right? Where you will have a split between votes and value, because sometimes people will have voting shares and non-voting shares, and you'll have to figure that out. Doesn't usually happen where they wouldn't be associated anyway, but that one does arise in real life. So any questions about that problem? Okay, seeing none, let's flip to slide 20, which is our last substantive slide. And so in slide 20, we have the following situation. A owns 100% of ACO. A's sister B owns 100% of BCO. And A and B both own 30% of the shares of Publico, and given that it's a public corporation, the other 40% are owned by arm's length shareholders, presumably who have acquired their shares through an exchange. So that is our starting situation. The question is, are the corporations associated? And again, by now, you should strongly suspect that the answer to this question is yes, everyone's going to somehow be associated. So, starting point here, okay, is as always that in this case, it matters who's related and who isn't. So our starting point is A and B are obviously related to one another under paragraph 251(2)(a. Because they're related by blood. So fine, we know they're related. And therefore we know that they, again, both for relatedness purposes, they should be a related group in respect of Publico, because related people are basically always a related group. And we know as well that they're a group that controls a BCO, or Publico in this case, because of paragraph 256(1.2)(a). So that's an important point. So, an important point. And I think the other thing to keep in mind as well is that because they own, this group owns more than 50% of the shares of Publico, it shouldn't matter because of subparagraph 256(1.2)(c)(1), whether they own just value or just votes, or some combination thereof, it probably won't matter. They'll be deemed to control Publico no matter what. So we can then start applying our association rules, right? Our normal association rules. And so we say, okay, well, Publico is, we can ignore the unrelated shareholders. Publico is controlled by a related group AB, and ACO is controlled by individual A. So our relevant rule is paragraph 256(1)(d), and we have the relatedness requirement that's satisfied, and our cross ownership requirement is satisfied because A owns 30% of the shares of public corporation. So we've done it. They are, ACO and Publico are associated with one another under paragraph 256(1)(d). And given that Publico and BCO are, ACO and BCO are mirrors of one another in relation to Publico, then we know the same analysis applies to Publico and BCO, and that they must both be associated under paragraph 256(1)(d). So that's all well and good. And then we have to determine if ACO and BCO are related to one another. And, again, ordinarily we would say no, right? That under paragraph 256(1)(c), they're both controlled by an individual. The individual is related to the individual who controls the other, fine. But there's no cross-share ownership. So you'd say, okay, under ordinary association rules, they can't be associated, all well and good. But again, subsection 256(2), as it has done in almost all of these problems, rears its head. And because ACO and BCO are both associated with public co, they're deemed to be associated with one another. And that's it. Everybody's associated, right? And so now you say, okay, well, public co is not a CCPC because it's a public corporation. And therefore, for the purposes of section 125, ACO and BCO are deemed not to be associated with one another. What you will find is that is entirely cold comfort, because they're still associated with PubCo, whether for the purposes of section 125 or for the purposes of any other provision of the Act. And so therefore, they're going to share public co's taxable capital. And since I don't think there's any Canadian public corporation that would have, aside from one of those like blank check TSX venture corporations, there really isn't any public corporation that would have taxable capital of less than 15 million Canadian dollars. So it's not going to matter. No one's going to get a small business deduction, even though they're not associated for the purposes of section 125, because public corporation is not a CCPC. So not a great result for anybody there either. Okay, anybody have any questions about that problem? Okay, seeing none, and assuming that we have no further questions about anything we talked about today, I'm going to propose that we call it a day, since we have 12 minutes left, and I don't think we're going to make material progress on the next topic with only 12 minutes to go. So last chance for questions. If not, we'll stop recording and we can all log off. Okay, well, I will see you next week, and this video will be available on the world's lamest YouTube channel.